welcome to this session. Welcome all. We are talking today about the EU Data Act, European Union regulation about the sharing of data, and in particular what businesses need to know about this regulation. This is well, our main subject. We will take 1 hour to explore the Data Act. In order to do that, I am with Leila Sayssa. So Leila, maybe you can introduce yourself.
Yes, hi everyone. I'm Leila, the legal content manager at Dastra, and also a jurist in French.
Legal officer, lawyer, yeah, and CIPP certified
Yes.
for the one who knows that. And for me, I am Jérôme de Mercey, one of the co-founders of Dastra and COO. In particular, I worked especially in the French DPA. And we will start now. Just a quick word about Dastra. If you don't know us, so Dastra, it is a concatenation of about data and strategies. This is a great example of why we are talking about the Data Act today. We were founded in 2020. We are a SaaS platform to govern all the privacy and data compliance matters. In particular, GDPR, Data Act also, but also AI governance. So our main focus is to help DPO and compliance team about data compliance. So we today have more 300 clients, and of course we are based in France, but also with a scope in Europa, especially in UK and Germany today. So do not hesitate to meet us at dastra.eu. What we will talk about today in three key points. First thing, why we are talking about Data Act today. The idea is to understand, of course, the European context and the key objective of the regulation. And after that, we will explain and go deep in details, explain the Data Act with a Q&A session, with explanation, and to give you key insights about this regulation and practical aspect of the regulation, like the obligations, the enforcement, the relationship with GDPR, and the focus on two main critical areas that we think it is very important for businesses today, especially Internet of Things and a cloud provider. And third point is to give you a practical implication for businesses. We have made a checklist, and we will give you, of course, the content and yeah, to help you to know how to handle it right now in a practical way. And we have prepared for you a Data Act Readiness assessment tool. This is a questionnaire, an assessment questionnaire available in Dastra, and we are very pleased to show you that and to explain how to get it right now. So yeah, a little quick sneak peek of the questionnaire. Yes. Today is directly accessible in Dastra, and we will show you that at the end of the webinar. And the idea with this questionnaire is to make it simple for you and to give you a quick assessment to know what you need to do. So, what is the EU Data Act? The EU Data Act, first thing, it's a regulation like GDPR. And this regulation, why we are talking about that today, it's because it came into force on September 12 this year, and it imposed new obligation. And we will see that in the second part, but new obligation in terms of data sharing, data access, data governance, contractualization, and it is very important to understand the limits and the obligation. The idea with the EU Data Act is to empower the sharing of data across services. With three things important. So fair access to data. The idea is to give access to promote an equitable access to and use the data generated by connected products and by related service. And we will see that in detail. What is a connected product? What is a related services? So the idea is to promote the connections, the sharing between devices. It also empowers the user data rights. The user of a device, of a connected product, for example, or a related service, must be able to access and share the data securely and without unnecessary delay. The idea, what we can say with the Data Act, it's a great way, a materialization to a concrete way to empower the data portability. You have the rights of portability in the GDPR, for example, and with the Data Act, it's something that is being a reality. And of course, the Data Act, we will see that it doesn't cover only personal data. It is also for non-personal data, but it is a great way to enforce the right to portability and to give for the individual, for the user, this possibility. Of course, the coverage of the Data Act, as I said, is not only personal data, but also non-personal data, raw output, pre-processed information, and metadata. What we will see today and why it is important for us to talk about that, we consider that there is two critical compliance areas to highlight. The first thing is the IoT, the Internet of Things data management. So there is specific rules in the Data Act for the Internet of Things. So what is Internet of Things? It's a device. It's a material device. All the data that are generated through device, material device, like a watch, for example, a connected watch. It could also be a heater. I spoke yesterday with a client who is in the heater ecosystem, and of course they are deeply concerned by this Data Act because it is a connected product. So the idea is to talk about IoT, data management, and the second area, very critical in our sense, is cloud service switching. So the possibility to switch between two cloud providers and to ensure portability between these two providers. So cloud services, IoT, two main compliance areas that we need to focus on today. And of course, the EU Data Act has a lot of other obligations about transfer, about other things, but it is, to be honest, quite complicated to understand everything, and we don't have time in this hour to do that. So That's why we are giving you a focus on these two compliance areas. All right, and in order to answer all these questions, Leila, who is our legal expert, and she has worked a lot on the Data Act to explain it and to understand all the implication, and she will be answering all our questions today. But the first question to answer, of course, is what does the EU Data Act cover in scope? What is the scope of this regulation?
Yes, thank you, Jérôme. So, as he said, I'm going to be answering several questions. It's better this way to understand things in a fluid way. So first, the main actors here and who should be respecting or putting in place the obligations that the Data Act covers are mainly the manufacturers of connected products, and we're going to explain right after what is the connected product and what is a related service. So the main actor are the manufacturers and the service providers. But specifically, the manufacturers of connected products that have been placed on the union market, regardless of the place of establishment. So for a connected product actually to fall in the scope of the Data Act, there's this notion that it should be placed on the union market. It's quite similar to the AI Act for those who are familiar with it, because we shouldn't forget that this is also a product type of regulation. So the notion of placing a product on the market means to make it which it means to first making available of a product on the union market, and it is placed on the market only once. So it refers to each individual product, not a type of product. For example, it's not about I don't know, connected healthcare watch. It's the specific product that we're talking about that should be placed on the market, and that's only once. And there should be a transfer of ownership or possession or any other property right between the two economic actors. So, for instance, if the product is placed on the market, there should be this transfer of ownership with the user, so that we could be able to talk about a connected product and the obligations that the Data Act covers. And it's important to know that this the place of establishment of the manufacturer is not relevant here. So the Data Act could still apply even if the manufacturer is established elsewhere, for example, in a third country, as long as the product itself is made available on the union market. So if the product is manufactured in a member state, so in Europe, only to export it to a third country, here the product is not considered to be placed on the market. That's why the notion is very important, because you could, in one case, be in the scope, and in another case, be outside of the scope. So
there is a little difference with GDPR here, because it does not matter in GDPR if you
it's not the same reach.
Doing personal data in your European Union or not. If you're based in European Union, you are subject to the GDPR. But okay, it is not the case.
It's not the same, and that's why understanding this is key. And if you want, there are a lot of exceptions, nuances. So if you wanted to understand this more, you could refer to the Blue Guide on the implementation of the product rules of the European Commission that was available in 2022, which explains all those different types of exceptions, of what's in the scope, outside the scope. So and again, on the transfer of ownership, that's also important. So if we're talking about a mere circulation of the connected product on the EU territory, this is not sufficient to consider that it has been placed. There should be a transfer of ownership. Same for the service providers. So the service providers, we're talking about services here that are in connection with the connected product. We're going to see it a bit further in details now. And also, there is no requirement for them to be established in the EU. So same thing that I explained for the manufacturers. There are also other actors here. Actually, there is this notion of data holder in the EU Data Act, which is really important. It's also here, irrespective of the place of establishment, so in EU or not EU. But the data holder actually means the person that has the right or the obligation to use and make available the data. So product data, service-related data that we're going to see. And here, so what's important to know here is that a manufacturer, that we just saw, could be the data holder, or the service provider could be the data holder. What's key here is to know who actually has the access to data. So the role of data holder here can be outsourced. For example, a manufacturer may contract out to another entity the role of data holder for all of or a part of the connected product. So if I'm manufacturing a connected healthcare watch, sorry, I'm not automatically the data holder. I could be outsourcing the data, the availability of the data, the access to the data to another entity, which will be considered the data holder. And it could be a company that provides a related service linked to the connected product. So it's not automatic that the manufacturer is the data holder.
Does it mean that the manufacturer needs to don't have access to the data? For example, the hosting of the data needs to be on the data holder today.
Yeah, yeah, and so to determine who the data holder is, it does not depend on who produced the hardware or the software, etc. It depends on who controls the access to the available data. That's really the key notion here. And also, it's important for the users of your products or of your services to know who is the data holder. So you have to inform them of the identity, quite similar to when you have to inform them of who's the controller in the GDPR. Then this has to be communicated to the users before signing the contracts. So the user agreements, the service user agreement, the sales, to actually buy a product. This information has to be available in those types of agreements. So here we have a chart that the European Commission included in their FAQ on the Data Act. So for those who don't know, there's an important FAQ, like 50 pages long, of the European Commission that explains those notions, gives a lot of examples, because the Data Act on itself is a bit technical, a bit hard to absorb. So the FAQ is really important to grasp concretely those notions. And here the flowchart illustrates a situation where a user enters into two contracts. So for the sale of the connected product on the left and for the provision of the related service on the right. And it establishes the legal relationship between the user and three separate data holders. The data holders here are circled in blue, just to give you an example that it can be the manufacturer, it can be a component supplier of the manufacturer that actually holds the data and has access to and can give access to the data, etc. So it doesn't have to be the manufacturer itself, but it also could be the provider of a certain component that is necessary to the manufacturing of the product. That's it. It's just a small example. Also, a manufacturing company can be both a user and a data holder at the same time. So that's also important because let's say the manufacturer of the health watch is a user of the robots, for example, that are used in their own factory, but is the data holder of the connected watch. So there's also, it's quite similar to when you can be a controller or you can be a processor at the same time. That's also important to be transparent about your position to your users. So let's understand a bit more the connected products. Of course, there's a definition. There's a legal definition that is given by the Data Act in Article 2.5. But I won't read it all together. You can check it out. But to summarize, it's a connected product is a physical item that can generate, collect, or obtain data concerning its use or environment, and can communicate it via connection. It can be Wi-Fi, it can be Bluetooth, it can be on USB, or it can also be on the device itself. So, for example, we all of us know a lot of connected products in our lives. It can be smart vehicles, it can be wearable health trackers, as I was saying. It can be MRI scanners, virtual assistants also. So it covers quite a lot of products that are in our life, actually, currently. And the related service. So the related service is any digital service that can be installed on the product or not necessarily on it, but that allow the product to operate in a specific way. So it can enhance the functionality, it can enable the users to get more value. For example, a mobile app that on which you can control the lighting systems of your house. It can be a platform to monitor the performance, or to monitor like also the applications where you can see all the data of your healthcare app, of your healthcare watch. So the service here has to be related to connect to the connected product in a certain way. So the relation has to be existent between both. And so there are two basic conditions. Sorry. To actually talk about a related digital service. And that's the two-way exchange of data between the connected product and the service provider, and that the service must affect the functioning, the behavior, or the operation of the connected product.
It's very important to have a product, actually. In the Data Act, it's a product regulation, like the AI Act, and so it regulates product and connected product, because product, of course, they are everywhere in our life, and so there is this notion of the device, of the something hardware in the Data Act, and of course all the data, the soft that is necessary to collect, to generate the data, and to use the data on this product.
So it's not only the hardware, it's also the software and the services that can allow the product to function, that are in scope here.
Thank you. What are the Data Act obligations? So what we need to do with these connected products, with these related services, and if we are a data holder, for example, what is our main obligation under the Data Act?
So here there are several obligations. As we said, it covers a lot of notions, a lot of obligations. This is a quick overview in two tables before we do a deep dive into the two critical ones. So there's the pre-sale data transparency that I was talking about. Before signing a contract with your users, you have to tell them who the data holder is, how the data is stored, are you sharing the data to a third party? So there's a list of specific mentions that should be included in the contracts and that are provided in the articles of the Data Act. Also, of course, to enable the user to access to data. So this is the main access and data sharing obligation that we're gonna deep dive into. There's also the obligation to facilitate the third-party sharing, so a user can actually request from the manufacturer or from the service provider, or actually the data holder, to share their data to third parties. And the third party here could also be a public authority. So the Data Act covers the case where a public authority will request certain data and it will explain what are the emergencies, what are the situations that are covered here, what is the matter of public interest. That's a whole other aspect, so we won't have time to get into. And there's also a specific notion of refusals and exemptions that we will also see. So how can I, as a data holder, refuse to share data? How can I limit the data that I'm sharing, and why? What are the exemptions that are covered? And also, of course, to explain how I'm using the data here. So as Jérôme said, it can be personal data or non-personal data. We know that personal data is quite covered by the GDPR, but there's also the non-personal data here. So we have to explain and get the user consent to use the data, and what are the safeguards that we have to put in place, and what are the prohibited uses of the data here. And there's this obligation to appoint an EU representative. So as I said, the data holders could not be established in the EU, but it's important here to appoint an EU representative, which is a familiar notion that we've seen in a lot of other regulations. So the European Commission is still working on the model contractual terms that will cover the B2C, but we already have the model contractual terms for the B2B data sharing and the cloud computing arrangements that are available and that were written by the expert group mandated by the European Commission. So it's not the Commission itself, but it's the expert group who already provided those in 2022. But we are still awaiting for the official ones from the Commission about the other types of data sharing. So that's a quick overview. There's also the obligations that are specific to cloud providers, so data processing providers, that we will see a bit later. And here the main notion is to include the mandatory portability clauses in the service contracts, and to enable the switching from one cloud, for example, or provider to another, as Jérôme was explaining before. So that's it. That's just a quick overview. Let's maybe.
Yeah. Yes, that's what. Just to remind some things. This is all this obligation. They are for the data holder, of course. The data holder, it's like the data controller in the GDPR, in fact. And you mentioned the consent to use non-personal data. In your mind, do you think it is the same consent as GDPR, or there is something quite less more restrictive than the GDPR is?
I feel like it's a bit less restrictive because it can simply be covered in your terms of service,
contract,
it's in your contract. It's not the same notion as the one that we see that is quite restrictive in the GDPR. Although you still have to collect the consent beforehand. So if we talk about the main thing that people think about when we talk about the Data Act, it's mainly the data sharing and access obligations. So the idea is simple. The data holder should enable the user to access to their data. There are some technical requirements, that the data should be provided in a freeway, machine readable access, for example, CSV, PDF, whatever the format. But the access should be given to all data that is generated by the use of the product or the service. We're gonna also cover all the data. Like, I'm gonna explain what actually we mean by the data here. But so the important idea to keep in mind is that the products or the services should be designed in a way that this access can be provided. It doesn't have to be a direct access. So the data holder does not have the obligation, for example, on the connected product itself, on the watch. So let's take the example of the watch. They don't have to make it so easy for me that I can directly access all the data. The access could also be indirect, but as long as it's there, as long as I can access, if it's through a request that I make to the data holder, or if I can access it directly. In any case, it should be easy, it should be secure, and it should be in a format that is machine readable, which reminds us a bit of the data portability, of the details of the GDPR on this. So since the entry of application, which was the 12th September, the products that were already on the market, as well as the new products, must allow for this data access to be made by the user, right? But they can choose whether to do it directly, as I said, so on the application or not, indirectly.
By design.
By design, which here can be done through a request, as I said. And there is no better way. It's just two different ways that are available to the data holders. And yeah, oops, sorry. So I wrote an example here. So the car owner gains access to all the maintenance logs, for example. A tenant can request detailed smart home data. So there are not only personal data, as there is a common thing to access our personal data, but here it's given us the right to access the non-personal ones. So what data are we talking about? What is the data in scope here? Of course, it covers personal and non-personal ones, as we've already said. But most importantly, the data that is covered, or that is in scope in the Data Act, is what we call raw and pre-processed data, which concerns the performance, the use, the environment of the connected product, and that is readily available to a data holder. So when we say readily available, it means that there is no need to have a disproportionate effort to go beyond a simple operation to get the data. It's only the data that is generated, collected by the connected product, by the service. And so here, the product data could be, for example, let's say
could be logs, for example, logs in the
logs, exactly,
of a device, yeah, or just the data represented in the device, but
yeah, and
do
it can
you have
also
that? Yeah,
it also includes metadata,
yeah,
which is also
metadata.
important, which includes the location, the weather, the time. So those are metadata is sometimes data that we don't consciously think about, but that actually gives context to the whole data. It's quite important to know that they can access the location, that they can access the time. So those are all
basic. This is basic data from the device.
Yeah,
actually.
exactly.
And
exactly.
this is Brussels. This is in the non-transformed data. Do you need to explain to transform the data before granting the data to the user, or just purely basic data like this without transformation?
Purely basic without the transformation, because actually when you enrich the data, so when we talk about inferred or derived data, which are notions that we also know from the other regulations, the data will become out of scope. So it becomes out of scope because it constitutes like a new added value, a new insight that goes beyond the basic data, that goes beyond the nature of the information that is generated by the product or the service. So whenever we're talking about inferred or derived data, know that there's like a substantial modification in the cleaning and the transforming of the data, and here it's out of scope. Also the content. So For example, I don't know, we're talking about a digital camera. You have to provide here the readily available data, such as the usage patterns, the timestamps, the location, but you're not obliged to share the content itself. So here in particular, the audiovisual content. Content can be textual, it can be audio, it can be audiovisual. But as long as we're talking about content, which is a result of a creative process that is designed for the human consumption, it's going to be out of scope. So this is also important to know which data we're talking about, of course. The European Commission has summarized this in a table that you can check out in the FAQ.
We can think about, for example, if you are using the data, personal or non-personal data, on a device or multiple device, and you are merging this data with other services, and it gives you a score, for example, for health score. I don't know. It may be something that it is interesting, and for example, an insurance company is using that, and so in the Data Act, in this case, in this example, it has no obligation to share the score of the person, for example, that is enriched, that is calculated.
Exactly, because it's enriched
based, of course, on the data, but it is not the data involved in the data sharing process provided by Data Act.
Exactly. Exactly. So what we just explained is just summarized also in this chart. Is just to get a concrete illustration. But here, as you can see at the top, the data holder has the data of the connected product or the related services that is bought by the user. And then the user can request the data holder either in a direct way or indirect way to share the data, to access the data. And if it's indirect, there's a possibility to have compensation, but that's quite, there are certain conditions to cover. And it can also be shared to a third party, which we're going to see now. So sorry, how can I? Yeah. So the user can also request to share the data to third parties, and this should be done without delay and without discrimination or unnecessary restrictions. So here the data holder should facilitate this sharing, and it shouldn't make the data holders should not make available the non-personal data to third parties for commercial purposes other than to fulfill the contract with the user. So that's an important exception. They're also not allowed to use the data to develop a competing product. So those types of restrictions should be governed in the contract that data holders should have with the third parties or the user with the third party. But it's a restriction. It's a prohibited action even to use this data in order to develop a competing product.
Yeah, that's very important because the business part, we don't want to have a personal or database.
And also, if you're considered a gatekeeper under the Digital Markets Act, which we don't see gatekeepers every day, but we know the big ones. But also, that's another prohibition to share it with the gatekeepers as understood in the GMA. So those are one of the exceptions that I just talked about. But there is also data exemptions that we just saw, the content, the enriched data. So keep in mind that this can be out of scope. And there is also exemptions that can be done, that can, so the Data Act, it can exempt micro and small enterprises from the data sharing obligations that we just covered under specific conditions. So they do not apply if the sharing obligations do not apply if the connected product or the related service was manufactured or designed or provided by an SME, as long as there is no link to a partner company that is a larger one. So those types of notions are covered in an EU recommendation of 2003. You can check it out also for further details. But as long as the enterprise here is not acting as sort of a subcontractor for a larger company, they can be exempted. But if there are links that maybe are used to contour this type of exemption, then it does not work. So they have to operate independently, kind of. And there's also, for another type of sort of grace period that is given to medium-sized enterprises, but only if it has recently become a medium-sized enterprise, so within the last year. That's also another type of condition. So those are kind of, limits to the scope of the obligation here. And the most important ones that the data holders can actually base a refusal to share, or to share maybe a limited data, or not share the data at all with the user, are two types of safeguards that are called handbrake safeguards in the Data Act. And it's the trade secrets one and the security concerns. So the trade secrets handbrake is that is covered here is it's actually when you want to when you fear that the data that you're sharing is going to disclose a certain type of information that is considered to be your trade secret. So you are allowed here to take all the necessary measures prior to the disclosure of the data to preserve the confidentiality of the trade secrets. So you can base your refusal to share or any other type of limitative action on this, as well as the security concern, which is the security handbrake, which if you feel like also if you're sharing the data in a certain way, it could undermine security requirements of the product itself or of the software or the service itself, that could affect maybe the health, the safety, the security of the persons here. So
I think it should be justified, of course.
Of course, which the other, if you want to base so your refuses on this, you have to justify it in writing to the user, and you have to also know that the user here can have can go through like redress mechanism. They can go to court. If they want to contest your refusal, they can, and the Data Act gives them the ability to. And also important that you have to notify the competent authority here of your refusal of access. So there would be the member states should designate the competent authority that is in charge of surveillance of the Data Act, of the compliance. And so the data holders here, whenever they want to not share the data, they have to notify the competent authority. Don't hesitate if there are any questions. And an important thing to keep in mind is the alignment with the GDPR here, because as we said, the data can be personal data, not only non-personal. And whenever we're talking about the personal data, of course, the GDPR remains applicable. So all the principles like legal basis, minimization, anonymization, DSRs that could be different, data subject rights that could be different than just the access. So everything still applies, which means that the companies should comply simultaneously with the GDPR and the Data Act whenever they have a data set that includes both types of data. And so the Data Act here sometimes complements the GDPR for example, when it gives the real-time access to portability and etc. So it kind of complements, the Articles 15 and 20 of the GDPR. And sometimes it comes to restrict the reuse of data by a third party. That we just saw, for example, that they cannot use it to develop a competing product, etc. So it either complements or it kind of restricts some aspects of the GDPR, but in any case, they have to be read together, and companies have to comply to both, of course, when they have both data sets. And there is also this difference actually to make in two scenarios. If your user here, the user of the connected product, is a data subject or not, is the concerned data subject or not, because the request to share data or to access data could not be made by the data subject itself. It could be someone else. It could be another entity that is making the access here, the request. So you have to distinguish whether the user we were talking about is the data subject itself or not. And if it's not the data subject, then the data holder should figure out which legal basis they're using here to access the data. So there's this combined vision of the GDPR and the Data Act here. Because the Data Act, because the Data Act itself is not the legal basis here. It's that you should make sure that there's the GDPR legal basis whenever the user is not the data subject. So that's it's quite important also to keep in mind.
It could be complicated sometimes to know
exactly.
what legal basis to use, and of course how to inform the individual about the data sharing if it's a case, and maybe you should not share the data from the individual, of course.
And it could be, that the providing data is necessary for the performance of the contract, which is the base of, or it could be a legitimate interest of the data holder or the third party. But it's important to know which ones and to clarify and to inform the users on this. And so the last kind of deep dive is the cloud switching provisions of the Data Act. Here, it's mainly all types of providers of cloud services, SaaS platforms, anything that is related to providing processing data processing services, which are defined clearly in the Data Act. But here, mainly the objective was to require that the switching between providers be free of charge, efficient, and smooth, so that there is no vendor lock-in. So there is no one that kind of holds the users and that doesn't let them, have the freedom to switch. And here, it's to promote, a competitive digital market within the EU. So the Data Act will put a stop to the exit fees, to the lengthy, complex procedures to switch between providers. And so it gives concrete obligations on their interoperability between providers that you can see here on the screen. What to add in the contracts, what technical infrastructure to have to ensure this interoperability, how to make sure that the business to maintain the business continuity, and under which deadlines, which ones you have to respect. So again, that's a lot of details to cover, but just to give you a quick overview here. And keep in mind that the European Commission will also finalize the standard contractual clauses that can be used. So that
that's quite a challenge for our sector, for industry. In France, there is already this kind of thing for the telecom. So the telecom operator, and when you are switching from a number, your phone, your cell phone, your number, your number of phone, your cell number, it is very easy because there is the portability of your number. And the idea is to continue this kind of work with other cloud provider. And
Exactly.
that's not easy, but it is in the same way with the data portability, with the right to portability. It is in the same movement, and of course it was a challenge, and industry needs to talk, need to organize, to be able to answer for this obligation
In
of the
a
data.
seamless way, in an easy way for the users. Yeah. So of course, if we talk
What
about
about enforcement?
so what
Big
about the
question.
enforcement? So the member states should establish their regimes by September 12, with penalties, of course, that it should always be effective, proportionate, and dissuasive, which are notions that we already know. There could be fines, there could be compliance orders, there could be warnings, suspension of the data processing, quite similar to what could be covered in the GDPR. Important to know that there could be overlapping oversight, so there could be parallel investigations by DPAs or competent authorities, because we're going to talk about personal data and non-personal data. So it could cover parallel investigations and dual exposures, because claims can be triggered for both. And we might expect dispute settlement actions, which is also covered in the Data Act. There's a whole part about dispute settlement actions, which conditions how, why, the whole thing is explained in the Data Act, which could also include collective actions, because the users could be considered consumers, and we all know that the consumer as rights are much regulated, and there are a lot of directives that could also come in play. So that's also important, of course, to know for the businesses. And lastly, so there are a lot of practical implications for the Data Act, a lot of things that the organizations could do. Know that the Commission is implementing to launch a legal help desk that can assist the companies on the guidance, particularly on the trade secrets protection, that can be used, as I said, as an exemption. This legal help desk which will help people like organizations to implement. But until then, there are some steps that the organizations can do, like identify, of course, firstly, the connected product and the related service, and to catalog, if possible, all the personal and non-personal data that those products or services can generate, and update it in your record of processing activities, which can also help you clearly, see the gaps in your compliance, so that the mapping here, the data governance is really important. You have to update the contracts that with your users and your third parties, as I said, to tell them who the data holder is, what rights they have, what legal action rights they have, what safeguards are put in place. So the updating of your contracts here is also an essential step. But also the agreements that you have with the suppliers or with the cloud services that we saw, to reflect the fact that you shouldn't do what we call event or lock-in, to avoid the exit fees, everything we just saw in this other deep dive. So your agreements should reflect this. And of course, make sure that the processes that you have can give the users the possibility to have the access that we're talking about, so that technically it's feasible, whether in a direct or indirect way, but that it's in real time, that it's machine readable, that it's secure. So make sure to have all those processes in place, which could be quite lengthy and not always easy, but that's also essential. And to have the interoperability that we were talking about designed into the product, especially after 12 September 2026, because there's the time to to actually have those types of technical requirements into your product from the outset.
So a big, a big step here that in 1 year. So we need to have this implementation in the product, and of course to think about how to give a real meaning of the reversibility. You know, in the software environments, you already have the reversibility. So the idea, of course, with cloud switching, for example, is to improve that, to give access for user to switch cloud provider very easily. It is in the same way. So in technical parts for organization to understand how can I extract my data. How can I give the data in a right way, in an easy way, and for the user to implement it in another provider. So this is of course a question about know your data, govern your data, of course, and think about how can I extract them, how can I master them. Of course, it is very, very close to the personal data management with GDPR already. We need to do that, but here with the Data Act, we need to have a global view of what we are doing with the data in our product, in our business.
Exactly. And so just what we were saying, if you want to talk about the questionnaire for...
No, it's a great questionnaire, of course, that we are happy to provide and to give you in order to help you to know what you need to do with a task generation of tasks in order to have an action plan after the assessment. So you have an assessment with I think like 40
questions that cover those two main compliance areas that trigger that are important for businesses that we just saw. So with all of the examples of the Europeans FAQ to understand the exceptions, to understand the nuances, and to understand the obligations in a concrete way. So it's sort of like a checklist. Did you do this? Yes or no? It gives you like the assessment of whether you're ready or not, and most importantly, whether you have to comply with the Data Act or not at first. So you'll have a score, you'll have a completion statistic. You can collaborate with the user, several people on the assessment itself. So.
Yeah, so a very easy to use tool assessment, accessible directly in Dastra. So you need to, of course, to go through Dastra to log into Dastra. It is very easy. You can make a trial, for example, to have access to this questionnaire, and of course. We encourage every DPO to make this questionnaire, this assessment, and in your industry to know, because maybe sometimes we don't know exactly what we need to do. We don't know if we are involved in this Data Act thing. So this is a great way to start a documentation, to start thinking about it, and to prioritize your action on the Data Act. Yeah.
Exactly. So we will send an email
with all this information.
Yeah, with the information, with the important links. That's it. Thank you. I think we're on time. I don't know if there are any questions. There's a QR here to contact us.
Yes, there is a question. Adrien, exit fees. I think it is about cloud switching provision. For the SaaS are strictly related to fees correlated to the transfer of data, so the sharing, so the extraction and the sharing of data. Or does it rule out long periods of commitment?
No, it's specific to the switching, so the transfer here. It's not about the rest of the commitment here. We're talking about the the fact that the users should not have to pay exit fees to switch from one provider to another.
Oh, okay, there's a question. Thank you. That's it.
Do we have information when the final version of the contractual clauses will be released? So it was said that it should have been in September. I don't have further information, but I can send you the link of the. I'm gonna put it in the chat. The link of the already available clauses for the B2B and the cloud switching that were done by the expert group. We will send them in the email forward if you prefer. So that's already one type of clauses that are available.
Yeah, the E-Commission has a lot of work with data acts, a lot of standard contractual clause to write. So we are still all waiting for that. And of course, we didn't mention it, but in France, it is quite complicated today. So we need a law. We need a law to have a surveillance authority, and today it is quite difficult. So it takes time, but it is very important to have in mind that in 1 year there is a main obligation. For that, there is still something to. It is time today to start thinking about implicate your developer to design your products in order to think about this data sharing and how to manage your personal data, and of course to have a global view of all your process, personal and non-personal data, and linked to your assets, linked to your data set, and to know that. So to master it, so you need to of course to make a great data governance about that. It could be you as DPO or other team, compliance officer, data management team, etc., etc. But we deeply encourage to start thinking about the Data Act application.
Yeah, it's quite complicated, but we try to narrow it down. And we'll follow with the links and also the link to download the presentation. So.
Yeah. Well, many thanks.
Thank you for listening.
Many thanks, Leila, for this presentation. It was brilliant, and see you later for another webinar. Bye.
Bye. Thank you.